Article 98 of the Constitution deals with, as I mentioned out, the Secretariat of the Parliament. ठीक है, मैं इसमें ना आपको इंपॉर्टेंट पॉइंट्स बता देता हूँ जो कि आपको याद रखने एग्जाम के लिए, जो प्रीलिम्स में क्वेश्चन आ सकते हैं. पहला जो है इसमें वो है कि द आर्टिकल 98 says that each house of parliament, which is the Lok Sabha and Rajya Sabha, shall have a separate secretarial staff. मतलब ये बोला गया कि राज्यसभा और लोकसभा के बीच में एक secretarial staff नहीं हो सकता, अलग अलग secretarial staff होगा. This is given directly in the constitution itself. Okay, so separate secretarial staff. This can be a MCQ in the prelims examination. Second, it says that the terms of conditions, terms of recruitment and conditions of service terms of recruitment and conditions of service of the secretariat staff is decided by the president. Is decided by the president by making rules. Is decided by the president by making rules. Is decided by the president by making rules. ठीक है, इसमें 1955 के रूल्स बने हुए हैं लोकसभा और राज्यसभा सेक्रेटेरिएट को गवर्न करने के लिए प्रेसिडेंट के द्वारा, जिससे कि उनकी जो ऑर्गेनाइजेशंस में उनमें रिक्रूटमेंट किए जाते हैं और उनके जो ऑर्गेनाइजेशंस में ऑफिसेस हैं, जो स्टाफ हैं, जो सेक्रेटरी जनरल, उनके नीचे जॉइंट सेक्रेटरी और उनके नीचे जो पार्लियामेंट का पूरा स्टाफ है, उनकी कंडीशंस ऑफ सर्विसेज को वो किया जाता है, मॉनिटर किया जाता है. ठीक है. थर्ड इज अबाउट व्हाट इज कॉल्ड द क्वेश्चन ऑफ डिस्क्वालिफिकेशन ऑफ एमपी अंडर सेक्शन 8 सबसेक्शन 3. अब इस चीज़ पे ना लोकसभा का सेक्रेटेरिएट इज इन न्यूज़ रिसेंटली, सो यू कैन एक्सपेक्ट वन क्वेश्चन फ्रॉम द लोकसभा सेक्रेटेरिएट इन द न्यूज़, विच इज़ दिस दैट for example, what we can say in this particular matter is that in 8 subsection 3 it is written that the member shall be disqualified, and agar if he is, let's say, violation of the provisions given under section 8 subsection 3 which is 2 years, he shall be disqualified. तो इसमें क्या किया लोकसभा सेक्रेटेरिएट ने, जैसे ये हुआ आपने देखा था कि लोकसभा सेक्रेटेरिएट ने डायरेक्टली डिस्क्वालिफिकेशन का नोटिस निकाल दिया ना. यहाँ से दो स्कूल ऑफ थॉट्स निकल के आ रहे हैं. एक कहता है कि लोकसभा सेक्रेटेरिएट के पास पावर है, पावर टू इशू डिस्क्वालिफिकेशन notification. The Lok Sabha Secretariat has the power to issue a disqualification notification. This is one school of thought which is emerging. Power to issue disqualification notification under the provisions of section 8 subsection 3. This school of thought is also getting the evidence of saying it under the case decided by Lily Thomas versus Union of India 2013. I have already discussed this case with you to some extent. और Lily Thomas versus Union of India में क्या लिखा है कि as soon as a member is disqualified under article 8 subsection 3, he shall be immediately notified as disqualified, which basically means that it is the Lok Sabha Secretariat which will sign the decision of disqualification. एक जो दूसरा thought आ रहा है वो ये कह रहा है, school of thought which says that it is the president under article 103 who shall take the decision of disqualification and not the Lok Sabha Secretariat. So these people are saying that the Lok Sabha Secretariat should have referred the matter to the President, and President should have consulted the Election Commission of India and then found a way to disqualify it. Okay, so there's two schools of thought in which the constitutional question of disqualification. तो ये question आ सकता है, for example, MCQ के level पे, कि under the Representation of People Act, which of the following bodies have the power to notify the disqualification of a member who is disqualified under the Representation of People's Act? And one of the answers which can be given on the basis of the Lily Thomas judgment is the Lok Sabha Secretariat. तो इसको आप थोड़ा सा इस क्वेश्चन आंसर के हिसाब से अपने आप को आप प्रिपेयर कर सकते हैं, क्योंकि जो डिस्क्वालिफिकेशन का नोटिफिकेशन है वो जारी किया था लोक सभा सेक्रेटेरिएट ने इमीडिएटली आफ्टर द पर्सन वाज व्हाट यू कैन कॉल imprisoned, sentenced. Okay, and therefore this seems correct that it is the job of the Lok Sabha Secretariat itself to make the disqualification happen. So this kind of a thing is something that you can take a look at. Okay, this is one point I think I should have been clearly made you understand. Okay. Okay, Sandeep. Sir, can President decide on questions as to disqualification of members of the Parliament under the 10th schedule? No. No. The answer is no. The President cannot. Okay, Nisha and Abhijit both have questions from Article 117. One has question from 117 clause 1. One has question from 117 clause 3. So let me take a look at Article 117 over here. Okay, Article 117 clause 1 is a question. Okay, a bill or amendment making provision for any of the matters specified in subclause A to F of clause shall not be introduced or moved except on the recommendations of the President, and a bill making such provision shall not be introduced in the Council of States. इसमें amendment कहाँ लिखा है? आप क्या बोल रहे हैं इसमें amendment के लिए? Where is amendment written in Article 117 clause 1? रिकमेंडेशन लिखा है, अमेंडमेंट कहाँ लिखा है? अच्छा, इसकी बात कर रहे हैं आप, बिल और अमेंडमेंट मेकिंग प्रोविजन। इसका मतलब ये हुआ कि अगर आप कोई एक फाइनेंस बिल है जो आपने पहले पास करा रखा था और उसमें आप दोबारा अमेंडमेंट करा रहे हैं, मतलब उसमें कुछ आप मान लीजिए आपने पहले 50,000 करोड़ का टैक्स लगाया था, अब आप 70,000 करोड़ का टैक्स लगा रहे हैं, तो वो फिगर आपको इनपुट करने के लिए अमेंडमेंट करना पड़ेगा। तो बिल के लिए और अमेंडमेंट के लिए भी सेम प्रोसीजर है, ये लिखा है आर्टिकल 117 क्लॉज 1 में। डज इट मेक सेंस अभिजीत? ओके, Article 117 clause 3. A bill which if enacted and brought into operation would involve expenditure from the Consolidated Fund of India shall not be passed by either House of Parliament unless the President has recommended to that House the consideration of the bill. ठीक है, ये मैं समझा सकता हूँ। देखिए, मैं इसके पीछे का लॉजिक आपको समझाता हूँ। मान के चलिए कि लोकसभा है, ठीक है, इमेजिन दैट दिस इज द लोकसभा एंड दिस इज द राज्यसभा। Okay, this is the Lok Sabha and this is the Rajya Sabha. Clear? Now, let's say, for instance, the political party, ध्यान से सुनिएगा इस चीज़ को, the political party in power has a majority in the Lok Sabha, but does not have a majority in the Rajya Sabha. Now let's say, for example, if it has to pass a bill which is a financial bill, where it has to impose a taxation upon the consumption of cigarettes. Okay, let's say it's a financial bill. Now, because it has a majority in the Lok Sabha, we can see that a financial bill can only be introduced in the Lok Sabha. तो वो क्या करेगा? वो लोक सभा से इंट्रोड्यूस करा के इसको पास करके रख लेगा। Okay, and let's say, for example, within 1 year, the composition of Rajya Sabha will change so that this political party after 1 year will attain a majority in the Rajya Sabha. You see the point? So once this political party has attained the majority in the Rajya Sabha, the president, who is the nominal head of the government, will take this money bill and then introduce it into the Rajya Sabha. You see the point? So this kind of a provision has been given under Article 117 Clause 3, which says that a bill cannot be introduced in either house of the parliament without the recommendation of the president. मतलब directly जैसे यहाँ से पास हुआ वो राज्यसभा में नहीं जाएगा. It gives the power to the government of the day to introduce the bill into the Rajya Sabha at a time of its own choosing, and that is why a kind of a nozzle has been introduced to make sure that the president at some point of time has the power to say about when this kind of a bill is moving into the Rajya Sabha. You see the point? अगर तुरंत पास होती लोकसभा से राज्यसभा में चला जाएगा, राज्यसभा कॉम्पोजिशन नहीं है आपके मतलब कैलकुलेशन का, तो बिल हो सकता है कोलैप्स कर जाए. आपने लोकसभा से पास करके बिल रखवा लिया है और अब आप धीरे धीरे वेट करो, राज्यसभा का कॉम्पोजिशन चेंज होगा. जैसे कॉम्पोजिशन चेंज हुआ आपने उसको राज्यसभा में इंट्रोड्यूस करा दिया और अब राज्यसभा में जाके वो पास हो गया क्योंकि अब मेजॉरिटी आपकी है. नाउ लुक एट व्हाट आई एम ट्राइंग टू से एंड देन अगेन रीड आर्टिकल 117 clause 3, all of you. A bill which if enacted and brought into operation would involve expenditure from the consolidated fund of India shall not be passed by either house of parliament unless the president has recommended to that house the consideration of that bill. ठीक है, तो इसमें क्या है ना, प्रेसिडेंट को एक ब्रेक लगाने का मौका दिया है फाइनेंशियल बिल में कि वो डायरेक्टली राज्यसभा नहीं जाएगा, वो सिर्फ तभी जा सकता है राज्यसभा में जब प्रेसिडेंट ने उसको राज्यसभा की कंसिडरेशन के लिए फॉरवर्ड किया होगा, अन्यथा वो राज्यसभा में नहीं जा सकता है. ठीक है, आई होप दिस आंसर्स सम ऑफ योर डाउट्स. निशा, ठीक है. Should I explain the finance bill again? अच्छा, you wanted to discuss, some of you wanted to discuss this part, na? Article 105 of 105 Constitution Amendment Act. Just let me get a sense of it. I saw Charan and I was remembered about it. Right. So in Article 338B of the Constitution, the clause 9, the following provision shall be inserted, provided that nothing in this clause shall apply for the purposes of clause 3 of Article 342A. In Article 342A of the Constitution, the words socially and educationally backward classes, which shall for the purposes of this Constitution, the words socially and educationally backward classes in the central list, which shall fall for the purposes of the central government, shall be substituted. This is the part. Here. Notwithstanding anything contained in clause 1 and clause 2, every state or union territory shall by law prepare and maintain for its own purposes a list of socially and educationally backward classes, entries in which may be different from the central list. This is a question that a few of you had, right? I looked at the comment by LD Charan and I'm reminded of that. Now see, let's say, take an example to understand what it means to say. It does not mean that the state has the power. Just to be sure about the question or answer to this, it does not mean that the state has the power to enact or notify OBCs under its authority. The power is with the central government, that's sure. This amendment was brought into the Constitution. Let's say, for example, if I am a Chief Minister of Bihar, right? अब सुनिएगा ध्यान से इस चीज़ को ना कि आर्टिकल 1 जो 105 कॉन्स्टिट्यूशन अमेंडमेंट 2021 का, उसने जो 342A में जो अमेंडमेंट किए हैं उसमें क्या स्टेट को पावर मिलती है ओबीसीज को नोटिफाई करने के लिए? आंसर है नहीं. मैं आपको समझा देता हूँ क्यों नहीं है, उसमें क्या लिखा है. ना अब देखिए, मान के चलिए कि अगर लेट्स से if I am the Chief Minister of Bihar and I have promised the people of Bihar, a certain group of Bihar, that I will give them reservations under OBC. ठीक है? But now my power to give them reservations under OBC has been taken away by the union government. जो केंद्रीय पॉलिटिकल पार्टी है वो ओबीसी नोटिफाई करेगी. ठीक है, तो अब जो जिन व्यक्तियों को मैंने प्रॉमिस किया था कि मैं ओबीसी की पावर आपको दूंगा, वो व्यक्ति अब मेरे ऊपर प्रश्न उठाएंगे कि आप किस काम के, राइट? Now, since the power of me notifying the OBCs has been given to the union government, I still want to create I still want to keep a political, what you can say, currency with myself, जिसमें मैं अपनी एक लिस्ट बना के रखूंगा और उस लिस्ट का काम ये होगा कि मैं अपने लोगों को बता सकता था कि अगर मैं केंद्र में चला जाता हूं तो मैं तुमको ओबीसी नोटिफाई कर दूंगा. डू यू अंडरस्टैंड सर व्हाट आई एम ट्राइंग टू से? If a chief minister of a state is maintaining his list and he says that this is my official list, I stand by it. If you give me power, I will notify the people in this list as the OBC. Now, it happens to be the case that the power has been taken away from me and has been given to the union. But if you give me power to go in the union, I will notify you as an OBC. You see the point? So, the amendment which was made under Article 342A by the 105th Constitution Amendment Act did not necessarily make changes to the constitutional powers of the state to notify OBCs, but allowed them to maintain an official list of themselves to talk to their constituencies, right, and ensure them that if I were in power, either that the power from the union comes back to the state, I will notify you as OBC, or you send me to the Lok Sabha and I will notify you as OBC. So there is a possibility of a political connection that the people can still maintain with their constituencies even if they have lost the power. This was a demand made by the states. If the government cannot give the OBC status notification back to the state government, at least it should allow the state governments to not completely lose the constituencies of backward classes to the politics of the central government, right? And also it allows them to then find ways to either get the laws from central government back to the state governments or get the politicians from the state governments to the central government. Okay, therefore the answer is that it does not give, the maintaining of a list does not give the power to the state governments to enlist or notify their own OBCs. It is only a sense of political actions that they can take under it. ठीक है, all right. ठीक है. And doctrine of eclipse I can explain. What is doctrine of eclipse? It's the most interesting thing. Think about it very simple and categorically, and you will get it in one instance. Let's say if there is an Article 14 of the Constitution, or actually, let's take this. If there is Article 19 of the Constitution, which says that freedom of association is a fundamental right. Freedom of association is a fundamental right. ठीक है? Now let's say the state is trying to deal with the problem of gambling associations. ठीक है, gambling associations, मतलब people have created huge associations in which gamblers come together and play games which are lottery based, etc., etc. ठीक है, and these people have become so powerful and they have so much money that they are also vouching for saying that give us legal recognition, gambling should not be against the law, etc., etc. The state wants to deal with the menace of a gambling association. But the moment that the state tries to dismantle gambling associations, they go to the court under Article 19 and say that the state is interfering with my freedom of association under fundamental right. Now, of course, you can take the course that state has the provisions under Article 19 Clause 4 to restrict the fundamental rights, but the argument थोड़ा लंबा ही चला जाता है. अब let's say for example, if the state has a parliament which is very powerful, एक ही पार्टी का पार्लियामेंट है, एक आत्मता से पार्लियामेंट इस चीज को काम कर रहा है कि वो गैम्बलिंग एसोसिएशन को खत्म करना चाहता है. आपने गैम्बलिंग एसोसिएशन को तोड़ना शुरू किया, गैम्बलिंग एसोसिएशन ने कोर्ट जाना शुरू किया आर्टिकल 19 के अंदर. ठीक है, अब मान के चलिए कि आपके दिमाग में ये आ गया कि अगर आपको 2 महीने दे दिए जाए, इफ यू गेट 2 months, you will finish the problem of gambling associations in India once and for all. For 2 months, you will finish, if you are given a free hand, without any restriction, you will finish the problem of gambling association in India for once and for all. Now, the moment you try to touch gambling association, पुलिस जाती कुछ करती है, आप उनका डी लाइसेंस करते हो, डी रजिस्टर करते हो, तो वो पहुंच जाते हैं सुप्रीम कोर्ट के पास. सुप्रीम कोर्ट फिर आपके ऊपर हाथ पैर मारना शुरू कर देता है. यू आर गेटिंग इरिटेटेड बाय ऑल ऑफ दिस. तो आप क्या करते हो, पार्लियामेंट से एक लॉ पास कराते हो जिससे कि आप आर्टिकल 19 को सस्पेंड कर देते हो. मतलब यू जस्ट रिमूव आर्टिकल 19 ऑफ द कॉन्स्टिट्यूशन. 2 महीने तक आप आर्टिकल 19 को सस्पेंड कर देते हो, तो गैम्बलिंग एसोसिएशन के पास कोई आर्टिकल नहीं है जिसके बेसिस पे वो आपको सुप्रीम कोर्ट लेके चले जाए. और जैसे ही आपने गैम्बलिंग एसोसिएशन को अच्छे से निपटा दिया, आप जो सस्पेंडेड आर्टिकल है उसको दोबारा रिस्टोर कर देते हो. दिस इज नोन एज डॉक्ट्रिन ऑफ एक्लिप्स. डॉक्ट्रिन ऑफ एक्लिप्स का मतलब ये होता है कि अगर ये कोई फंडामेंटल लॉ है और अगर ये कोई पॉलिसी है, अगर स्टेट ने कोई पॉलिसी बनाई है और अगर स्टेट की बनाई हुई पॉलिसी इसीलिए इंप्लीमेंट नहीं हो पा रही क्योंकि वो पॉलिसी फंडामेंटल लॉ के विरोध में है और स्टेट बार बार कोर्ट कचहरी के चक्कर में पड़ जाता है, तो इसका मतलब क्या होता है कि जो ये पॉलिसी है ना, इस पे इस फंडामेंटल लॉ का एक एक्लिप्स पड़ रहा है. राइट? नाउ व्हाट द स्टेट कैन डू अंडर डॉक्ट्रिन ऑफ एक्लिप्स इज, फॉर सम टाइम when it wants to create a policy, it can skip the fundamental law out, and the time that it gets without the fundamental law is a free hand when it can create matters of policy and that bring the fundamental law back. This is known as the legislative activity of removing a law for some time, getting things done and then restoring the law back. Like for example, if land reforms have to be done in India, 1950s, but everyone is going to the court under Article 19, right to property. Under doctrine of eclipse, what can happen is that you can remove the, what you can call, the Article 19 right to property for some time, take 5 months and do all the land reforms. No one can go to the court because the parliament has amended the constitution of removing Article 19 away from the constitution. राइट? तो अब आप क्लेम कहाँ से करोगे? आप कहोगे आर्टिकल 19 में हमको फ्रीडम है राइट टू प्रॉपर्टी की, लेकिन पार्लियामेंट ने तो आर्टिकल 19 हटा रखा है, और हटा रखा है जिससे कि आपका जब तक तिया पांचा नहीं हो जाता, टिल द पॉइंट दैट दे हैव टेकन केयर ऑफ यू, दे विल नॉट रिस्टोर आर्टिकल 19. एंड वंस यू हैव टेकन केयर ऑफ यू, आर्टिकल 19 इज रिटर्न बैक. राइट? सो आर्टिकल 19 इज casting an eclipse upon the law. Either you can keep fighting with the Article 19 through a court, or what you can do is, if you have enough power in the parliament, you can create a constitution amendment act, remove Article 19, and once it's done, you can bring Article 19 back. This is what is known as, this kind of an activity, when it is done by the legislature, is known as a doctrine of eclipse. Does it make sense? Do we understand this? Cool. Okay, what is another doctrine that is remaining over here? Doctrine of eclipse, doctrine of severability, doctrine of what other doctrine did I say that we'll do? A doctrine of harmonious construction. हाँ, ठीक है. A simple one, doctrine of harmonious construction. Basically what it means is this, that let's say you have the union list, या फिर let's say I'll take an example of doctrine of harmonious construction. इसी एग्जाम्पल से आपको समझ में आ जाएगा कि अब फंडामेंटल राइट्स दे रखी हैं पार्ट 3 ऑफ द कॉन्स्टिट्यूशन में, और डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, DPSP, directive principles of state policy are given in part 4 of the constitution. Right? Now a huge debate which came before the Supreme Court, for example in the Minerva Mills case. प्रीलिम्स में क्वेश्चन ये आ सकता है, इन विच ऑफ द फॉलोइंग केसेस वाज द डॉक्ट्रिन ऑफ हार्मोनियस कंस्ट्रक्शन एस्टैब्लिश्ड टू सेटल द डिस्प्यूट बिटवीन फंडामेंटल राइट्स एंड डायरेक्टिव प्रिंसिपल स्टेट पॉलिसी. इन द मिनर्वा मिल्स केस 1980, in which the question that was asked is that among the directive principles and fundamental rights, which of them have been given superiority over by the constitution. अब सुप्रीम कोर्ट बहुत समय तक कह रहा था कि फंडामेंटल राइट्स आर सुपीरियर, और डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी के लिए स्टेट कह रहा था कि these are superior. Now, in the Minerva Mills case, the Supreme Court has said that the Constitution doesn't envisage any of them to be superior, but the fact that the interaction between directive principles and state policies must happen in the society without any constraint made by the state or the court, and eventually the society will decide which is superior. Okay, so harmonious construction means that you don't interfere in deciding something positively, leave two things as they are. They will have a juggling with them, and eventually sometimes the society will decide the directive principle is superior, sometimes the society will decide the fundamental right is superior. This is known as harmonious construction, that the harmony is constructed by their free floating interaction between the two, and the state or the Supreme Court should not try to hold one into superiority. It's a kind of hands-off approach in terms of making sure that the question of declaring something to be superior than another is written off. A similar doctrine was used by the Supreme Court in deciding matters between the union list and the state list, which is a superior list among the two. And the whole idea was that it should be left off completely. So harmonious construction is basically a judicial doctrine which says that the judiciary or the state should not declare something to be superior and something to be inferior. Superiority or inferiority shall be assumed by the harmony of their interactions with each other. So it basically entails that the superiority of something, the superiority, for example, of executive over the legislature, or judiciary over the executive, or executive over the judiciary, this kind of a language should not be applied. All of them should be left as they are, and the harmony between them will eventually decide what is superior and inferior. At different times, you will construct different superiorities and inferiorities. This is known as the doctrine of harmonious construction. I've explained doctrine of severability in the previous part of the video. You just have to go to the rewind of it and you'll find it somewhere. Okay. Yes, Shubhi, you are correct. Absolutely. It's a brilliant observation that doctrine of eclipse does violate the basic structure of the Constitution. Yes, it does. But remember, a basic structure of the Constitution was only invented by the 1973 Keshwananda Bharti judgment. Before that, doctrine of eclipse could have been applied because nothing like basic structure existed, and that is where the doctrine of eclipse became a kind of a relevant activity in the parliament, where it could actually move things about to push policy decisions, right? Article 31A, 31B, 31C are examples of doctrine of eclipse in the Constitution of India, where they expel judicial review under certain cases. For example, the 9th schedule. Can amendment in Article 342A be considered a centralizing? Of course, yes. That's a very acute observation. It is a centralizing tendency where the government union has not only taken the responsibility of scheduled caste and scheduled tribes notification, तो union government के हाथ में थे ही. OBCs are very indigenous to communities. You see what I mean? अगर एक state में कोई एक caste अगर general में है तो अगले state में वो OBC में आ सकती है, right? So OBCs are generally always in all commission reports attributed as best defined by the state in which they exist. So taking away this power from the state and giving it to the center is a little bit sociologically and anthropologically unclear. Is a good observation to say that it is an act of centralizing a tendency. Okay. See, citizenship I can't explain in the time that I have. You just have to read the Citizenship Act 1955 के कुछ चीज़ें हैं. That maybe will be enough. If you want to, for example, read citizenship for the prelims examination, I can refer to you in the Durgadas Basu, D.D. Basu book, Shorter Constitution of India. Shorter Constitution of India. You have a chapter, I think it is the third or the fourth chapter on citizenship. Just read that chapter and everything that you will have from the prelims perspective will be given in that chapter. Citizenship Article 5 to 11 and the Citizenship Act 1955. these are given very properly in the D.D. Basu Shorter Constitution of India. It's a book that you get for the preparation of the IAS examination. Okay. Okay, let me just at the brief finale of this discuss another important issue that I've been meaning to make sure that can be becoming a part of the prelims kind of a thing. The case is about the bail which has been given in what is known as the Bilkis Bano case. Right now, this case has become a little bit relevant because of the remission powers which are given under the CRPC, Criminal Procedure Code. So I'll just explain to you the facts about. The case is about the bail which has been given in what is known as the Bilkis Bano case. Right now, this case has become a little bit relevant because of the remission powers which are given under the CRPC, Criminal Procedure Code. So I'll just explain to you the facts about what basically is this happening. I think I'll be able to cover it in 10 minutes, and I feel कि थोड़ा बहुत इस पे prelims के question बन सकते हैं क्योंकि remission जो एक concept है, it is becoming more and more relevant in terms of the prelims paper. Now, see, the idea of remitting or commuting an offence is given as a power to the President and the Governor. We all know that, and I think you've covered that. That to declare that a sentence cannot be reduced or pardoned is a sovereign power which has been given to the President and the Governor. Clear? But you would be surprised to know that the power of remission is also given to the government, basically to the union government and the state government. Right? The requisite article, the requisite section for describing the power of remission is section 432 of IPC. We'll take a look at section 432 of IPC, and we will take a look at section 433A of IPC. This is something that you may not have heard about. Remission का मतलब होता है किसी का sentence कम कर देना, और गवर्नर और प्रेसिडेंट के पास तो पावर होती है कॉम्यूटेशन की, रेप्राइव की, रेमिशन की, ये सब आप लोगों ने पढ़ा होगा. पर इसके अलावा गुड कॉन्डक्ट के आधार पे स्टेट गवर्नमेंट और यूनियन गवर्नमेंट के पास भी, मतलब स्टेट काउंसिल ऑफ मिनिस्टर्स और प्राइम मिनिस्टर, चीफ मिनिस्टर और यूनियन काउंसिल ऑफ मिनिस्टर और चीफ प्राइम मिनिस्टर के पास भी पावर होती है किसी के ऑफेंस को रेमिट करने की. And that is given under section 432 of the did I mention IPC? No, it is 432 of the CRPC, the Criminal Procedure Code. Let me just pull it out, the copy of the Criminal Procedure Code, and I can maybe finish up the whole entire thing about the Bilkis Bano case and the Supreme Court judgment upon the matter and the Supreme Court bench which is being formed upon the case. Here, this is an article, a section that is going to be a little bit relevant, I feel, for the Bilkis Bano judgment to understand it, right? You have the power to suspend or remit sentences. ठीक है? इसको एक बार पढ़िए. When any person has been sentenced to punishment for an offence, the appropriate government may, at any time without conditions or upon any conditions which the person sentenced accepts, suspend the execution of a sentence or remit the whole or any part of the punishment to which he has been sentenced. You just take a look at this to get a legal clarity as to how it was possible for the government of India and the government of Gujarat to remit sentences of certain offenders who were serving a jail imprisonment under some charges of the Indian Penal Code. Okay. right? So this is basically the power to suspend or remit a sentence. Okay, this is Article 432. Again, let's read it. When any person has been sentenced to punishment for an offence, the appropriate government may at any time, without conditions or upon conditions, any conditions which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. Section 432 is a section under which the government of Gujarat had issued the instructions of the remission of the sentence of what is known as the Bilkis Bano gang rape case. And with the reference to section 432, we will also read section 433A. Take a look at this, section 433A. Please just read this. We'll be able to make some good about some 1 or 2 marks in the prelims just at the point of our departure. Please एक बार पढ़ लीजिए इसको 433A को. Notwithstanding anything contained in section 432, where a sentence for imprisonment of life is imposed on conviction of a person for an offence for which death is one of the punishments provided by law, or where a sentence of death imposed on a person has been commuted under section 433 into one of imprisonment for life, such person shall not be released from prison unless he had served 14 years of imprisonment. इसका कहने का अर्थ ये है कि अब सेक्शन 432 में दे रखा है that the appropriate government, which means that the state government or the union government, whoever has the schedule, let's say for example, if someone is doing economic offences and he has been changed. Now, if that economic offences falls under the subject of the union government, a subject of the union government, the question is decided by the union government of remission, and if it is in the state government, then it is decided by the state subject. ठीक है, तो अब इसमें ये है कि if let's say a person who has been convicted of an offence for which the penalty is a life imprisonment. Life imprisonment is imprisonment until death. जो उम्र कैद की जो सज़ा होती है वो होती है punishment until death. लेकिन अगर किसी व्यक्ति का कॉन्डक्ट अच्छा है तो उस लाइफ इम्प्रिजनमेंट को रेमिट किया जा सकता है, लेकिन वो रेमिशन तभी हो सकता है जब उस व्यक्ति ने 14 साल की इम्प्रिजनमेंट कर ली हो. डू यू अंडरस्टैंड द पॉइंट? इफ अ कोर्ट हैज सेंटेंस्ड मी फॉर अ लाइफ इम्प्रिजनमेंट फॉर एन एक्ट दैट आई हैव डन, देन if I am to apply for remission under section 432, it is necessary that I must have undertaken at least 14 years of imprisonment. इसीलिए कभी कभी what we hear in popular references that उम्र कैद is 14 years, क्योंकि 14 साल के बाद कई बार आप अपने अच्छे कॉन्डक्ट के बेसिस पे अपनी imprisonment unto death को रेमिट करा लेते हो सरकार के द्वारा, the appropriate government, which means the union government or the state government. That is why this kind of a little misunderstanding sometime arises that life imprisonment is imprisonment of 14 years. But no, life imprisonment is imprisonment of life, but if it is in condition to section 432 and 433A, then a person's life imprisonment can be cancelled after he has completed 14 years of imprisonment. ठीक. अब in the Bilkis Bano case, in the Bilkis Bano case, there was a kind of a series of events which happened. For example, the person, I think it was Radhesham Shah, who was the main accused in the Bilkis Bano gang rape case, he had filed a application at the Gujarat High Court for remission under section 432 of the CRPC, and also the Gujarat government had created a remission policy. Okay. The Gujarat government, I'll just give you a set of ways in which you can understand. In May 2022, Radhesham Shah, who was the main accused in the Bilkis Bano gang rape case, he had filed a petition in the Gujarat High Court. It filed a petition in the Gujarat High Court in which what he had said was that under section 432 of CRPC and what is known as the गुजरात रेमिशन पॉलिसी, गुजरात सरकार ने एक अपनी रेमिशन पॉलिसी बनाई थी कि किन किन ग्राउंड्स पे आपको रेमिट किया जा सकता है. तो जैसे फॉर एग्जांपल जो सारे के सारे गुड कॉन्डक्ट्स के ग्राउंड हैं उन पे आपको रेमिट किया जा सकता है. मतलब इफ़ यू आर वेल बिहेव्ड इन द प्रिजन, इफ़ यू आर शोइंग साइंस ऑफ रिफॉर्म्स एटसेट्रा अंडर दिस पॉलिसी, ऑल दोज कंडीशंस वर गिविंग अंडर विच यू कैन लेट्स से what you can do is you can take a kind of a recourse of remission in this sense, right? Now the Gujarat remission policy 1992, what basically we were taking a look at was that the Gujarat High Court में ये चला गया राजेंद्र एन शाह, राधेश्याम शाह, but the Gujarat High Court said that a remission cannot be granted. Remission cannot be granted. Okay, this was the judgment of the Gujarat High Court. Then this person went to the Supreme Court of India, and Supreme Court in its judgment, in its order, said to the Gujarat government that the application for remission of this person shall be considered. Consider the application of remission. Matlab it, in a way, the petition was filed, a writ petition was filed by him in the Supreme Court of Mandamus, in which the Supreme Court commanded the Gujarat government to consider his application of remission. Okay, and then later on what happened was that by 15th of August 2022, the decision was given by the Gujarat government that this person shall be remitted. Okay, the crime for which he was serving sentence was of rape and murder, for which he was imprisoned for a life imprisonment, matlab into jail until life. Okay, and the imprisonment was, I think, executed in the year 2008, right? And so 2008 till 2022 he had completed 14 years. I think 15 years, yeah, 15 years he had completed. So he had become eligible under section 432 of the section 433A of the CRPC, in which he was filing the petition for remission. 15 years it had completed, right? So these are some facts which maybe you can use in answering some question. अगर कहीं आ जाता है remission के आसपास का कोई question इस चीज़ पे लेके, ठीक है? Now the next point that is now raised is that some people have petitioned the Supreme Court because there is a problem with the order of the Gujarat government. The problem of the Gujarat government order is that the court which sentenced him to imprisonment was a CBI court in Maharashtra. And therefore, the petition which has been made into the Supreme Court by activists say that the Gujarat government does not have a jurisdiction as the appropriate government under section 432 of the CRPC. The appropriate government in this particular case should be the Maharashtra government. What basically had happened was that because of the some application filed by the petitioners in the Bilkis Bano case, they had said that they fear that in the Gujarat High Court or they will not get justice, so they asked for the permission of the High Court and the Supreme Court to transfer the matter out of Gujarat to Maharashtra. So the trial of this person in this gang rape case was conducted in Maharashtra, and the decision of life imprisonment was also given in Maharashtra. So the petition which is now lying before the Supreme Court is basically asking the question whether a CBI court in Maharashtra, which has sentenced a person who is residing in Gujarat and the crime was committed in Gujarat, can the Gujarat government have the authority under section 432 of the CRPC to remit a sentence? So this is the kind of a thing that is now at this point before the Supreme Court, where the Supreme Court is trying to create a bench to hear this matter. So इसमें कुछ ना कुछ development आगे होगा, but nonetheless things that you can remember from this particularly and specifically prelims is that the power of remission is not only given to the president and the governor, the power of remission is also given to the government, which is the prime minister and the council of ministers at the union, or the chief minister or the council of ministers at any state. The section of 432 says appropriate government. Okay, so both the union government and the state governments have the power to remit a sentence under section 432. Okay, and the proviso over here is that in case of what you can call sentences which are given for life imprisonment or death penalty, which have been converted to life imprisonment, a person cannot be remitted unless he has completed the 14 years timeline inside the prison. Only after 14 years can he be remitted. And in pursuit of this kind of a remission, activity given under Article 4, under Section 432, governments of various states have made their own remission policies. The Gujarat government has 2 remission policies, which can be asked as questions. Okay, the remission policy, because it was in news, so I'm just laying it out before you. A remission policy of 1992. And remission policy of 2014. These were circulating in the news, and therefore I'm just in a way laying out before you remission policy of 2014. Okay, so ये इस पे क्वेश्चन जैसे ये आ सकता है कि रेमिशन की और रेप्राइव की और जो सारी पावर्स हैं जब आप प्रेसिडेंट की पढ़ रहे होंगे तो उसमें बस आप एक बार ना सीआरपीसी का सेक्शन 432 और सेक्शन 433 ए भी पढ़ लीजिएगा. अ काइंड ऑफ अ क्वेश्चन फ्रॉम द बिल्किस बानो केस कैन बी आस्क्ड इन टर्म्स ऑफ मेकिंग दिस अ लिटिल बिट ऑफ अ हाईलाइट. ओके, ठीक है. Any last discussions that you want me to do? If it's pressing, वैसे तो बहुत कुछ है. I'm not sure if I can take all these questions at this point, but I'll just give you a brief about Office of Profit. I'll give you an understanding as to what it basically means, right? And also the specific points to learn and memorize from the prelims perspective. Office of Profit. What is an Office of Profit? Okay. Now, basically, look at this. Imagine this to be a situation. Let's say you are an IAS officer who's serving in a district, and because of the work that you have done within that district, you become immensely popular in that district. Everyone knows you by name and by face, and you've become very popular as an IAS officer in that district. So popular that you have the confidence that if tomorrow you get elections, if you step into fighting elections, you will be voted as a member of parliament or a member of legislative assembly from that district somewhere or the other. Okay, it's possible, right? If an IAS officer becomes very popular, he becomes a kind of a face of the public administration, has a kind of a vigilantism inside him, he can become very popular. And he also has the possibility of making sure that he can be कल इलेक्शन करवा लो, मैं खड़ा हो गया, मैं जीत जाऊंगा, that kind of an attitude, right? Now, the reason why an IAS officer who can become popular cannot at the same time when he is an IAS officer become a member of parliament or a member of legislative assembly is because of the disqualification given in Article 102 Clause 2, 102 Clause 1, which is Office of Profit. office of profit basically simply states this, that if you are a person holding an office in the executive organ of the state, you cannot hold an office at the same time in a legislative organ of the state. I'll tell you why. Because the concept of separation of powers that is exercised in India and even the concept of parliamentary democracy or parliamentary form of government exercised in India, both of them are structured in such a manner that the legislative organ, the parliament, is supposed to exercise control over the executive organ. Okay? The legislative organ is supposed to exercise control over the executive organ. A very good example of this would be this. Let's, for example, the salary of the Reserve Bank of India governor, RBI governor, is decided by the amendments made to the RBI Act, and the amendments to the RBI Act can be made only by the parliament. Now let's say if you have a very popular Reserve Bank of India governor, okay, and that very popular Reserve Bank of India governor fights an election and becomes an MP and forms a small political party and comes inside the Lok Sabha, right? And then within the Lok Sabha, he introduces a amendment in the Reserve Bank of India Act 1934 that the powers of the RBI governor should be expanded. You see the point? While he is the Reserve Bank of India governor, he becomes very popular, and he also becomes a member of parliament from Lok Sabha, and he has 7-8 MPs with himself, and he's made a little bit of a lobby of MPs, and he's pushing a legislation which gives wider powers to the Reserve Bank of India governor, which is himself. You see the point? So this kind of a possibility could have existed, and it's very easy to think, you know, in politics, for example, you see a same person is the president of a party, he's also the chief campaigner, he's also the chief minister, he's also, you know, possibly the most important face of election rallies, etc., etc. So politicians have the ability to occupy multiple role at the same time. It's not necessarily that they're doing a job of one kind of a category itself. Right? They have the ability to wear multiple shoes. President of a political party can also be the prime minister of the country, and he can shuttle between the two and do a good job about it. So it is possible for a Reserve Bank of India governor to also be a member of parliament and shuttle between the two. So it's not unthinkable not to do it. The only reason he cannot do it is Article 102 clause 1 clause A, that anywhere in which a executive organ of any person who's occupying the executive organ of the state is at the same time also present in the legislative organ of the state means that the seeker of the accountability and the person who is giving the accountability are both the same, which is a violation of two principles: separation of powers and parliamentary form of government, which means the accountability of the government to the parliament. And this is basically the definition of office of profit. So what it basically simply implies is that if you are holding a position under the executive organ, you cannot, while you're holding a position under the executive organ, become a member of the legislative organ. And I'm telling you, this is not entirely unthinkable. In fact, what is stopping a lot of IAS officers who are in a way populistic and vigilantistic in nature from getting tickets to MLAs and MPs by political parties is Article 102 clause 1 clause A, which tells that office of profit, which is an IAS officer, cannot contest into elections. So either you vacate that or you vacate this. You see the point? This is the definition of office of profit, that an executive cannot at the same time become a legislature, because the executive is governed by the legislature. And if you are maintaining yourself at the legislature, drawing some profit out of it or power out of it, if you are sitting in the legislature from which the profit and power is determined, then you're going to make yourself more profitable and more powerful. This is what is known as office of profit. Okay? Does it make sense? Now, let me give you one hitch about it. Under Article 102 clause 1 clause A, it is mentioned that a person who's holding office of profit under the it is mentioned that a person who's holding office of profit under the what you can call what you can call under the government of India or government of state cannot at the same time become a legislature. But the government of Indira Gandhi made an amendment to that particular point, and it said, it introduced, let's say for example, if there's an IAS officer who's very popular in the district, and I am a political party leader, and I watch that IAS officer and I say that अगर मैं इसको टिकट देता हूँ ये जीत जाएगा कभी ना कभी, right? Now, but the only problem that is coming in my way is Article 102 Clause 1 Clause A. But there is a way in which I can bypass it. The way I can bypass it is that what Article 102 Clause 1 Clause A says is that if the Parliament wants, it can specifically make a law to remove a particular post out of the definition of office of profit. So for example, if there's an IAS officer who's very popular and I know that if I'm given the ticket, he will give me one seat in my political party. What I can do is I can ask the Parliament, which is my political party, to make a law by which the IAS officer of this district can be removed from the definition of office of profit, which means that he can be exempted from the disqualification under Article 102 if the Parliament passes a law by a simple majority to that effect. You see? So eventually, if the Parliament wants that a particular person is getting very popular, etc., and he can be utilized for political gains, then the Parliament can make a law under Article 102 to create an exemption for that particular person. So for example, if an election commissioner gets very popular and he is very well respected, etc., and a political party thinks that as long as he is the election commissioner, he is respected. So the best way to utilize his political popularity is to give him a ticket right now. But he is disqualified under Article 102 because he is holding an office of profit. I can make a law as a Parliament to make an exemption saying that the election commissioner of India will not fall under the definition of under the disqualification of Article 102. And that kind of a power has been given by the Constitution into the Parliament. And this power itself was given to the Parliament by a Constitution Amendment Act made by the Indira Gandhi. It was a 1976 Amendment Act, or I think 1974 Amendment Act, which gave these powers to the Parliament to take one post if it thinks it is politically exploitable, remove it out of the definition of the disqualification of Article 102 Clause 2. Clause 1. Take a look at Article 102 to get a sense of what office of profit is. Okay. Take a look at this. A person shall be disqualified for being chosen as and for being a member of either House of Parliament if he holds any office of profit under the government of India or the government of any state. Okay, so this is something which is clear. But the additional point about it is, more important to hear. Other than an office declared by Parliament by law not to disqualify its holder. इसको आपको समझ रहे हो कि Parliament एक पर्टिकुलर पोस्ट को आर्टिकल 102 क्लॉज 1 क्लॉज ए के डिस्क्वालिफिकेशन से एग्जेम्प्ट करा सकता है. ये प्रीलिम्स में क्वेश्चन आता है इस तरह का, है ना, कि मतलब पार्लियामेंट हैज द फाइनल अथॉरिटी टू डिसाइड वेदर अ पर्टिकुलर पर्सन कैन बी एग्जेम्प्टेड फ्रॉम द डिस्क्वालिफिकेशन एक्सपोज टू हिम अंडर आर्टिकल व्हाट यू कैन कॉल 102 क्लॉज 1 क्लॉज ए. मेक सेंस टू यू? ओके, इट्स Ayush, who finally decides the disqualification as per Representation of People Act 1951? The President. Not even the President, the President in consultation with the Election Commission of India, whose opinion is binding upon the President. So the answer can actually be the Election Commission of India, but it will be constructed, अगर option में आया तो President with the consultation of the Election Commission of India. President plus the Election Commission of India. Okay? All right, I think that's all for today. It's been a very long day for all of us. Thank you for your time and patience. You've been extraordinarily patient and considerate. It only reflects the sincerity that you have for the exam. I'm really, oh, Deepak is here. Awesome. Good to see you, man. Give a shout out if we have met before on the chat. If we have met otherwise in offline online classes, give a shout out. I can remember some names. So yeah, Deepak, I remember. What is the confusion between LS secretary and president in that respect? The confusion is whether the Lok Sabha secretary should have gone to the president directly without having given the order himself. That's the confusion. You see? But the Lok Sabha secretary does not give any direct, what you can call, power under any of the acts to sign the notification. The explicit powers are given only to the president. So the question is whether the Lok Sabha secretary should have taken it to the president or he should have had the power to sign it directly. No act, either RPA or the constitution, gives the power to the Lok Sabha secretary to make any kind of a explicit order in this particular regard. The power is given only to the President of India under Article 103 explicitly. So that's the confusion. Is the power of the Lok Sabha secretary implied or implicit under the RPA, as Lily Thomas versus Union of India has observed, or it is not implicit at all? It has to be done by the president directly. Okay. Oh, Raksha, I remember you. Oh, thank you. It's nice to hear all of you guys again. Thank you for attending this session. Vedbani is here. Hi, Vedbani. My friends from Calcutta. Vidyut is here. I'm good. I'm just a little tired. That's it. But I'm happy. Good intellectual stimulation is always very fulfilling. All the best for your examination. I hope and I wish and I pray with all my being that you get what you deserve, and you have worked extremely hard sitting on this session. It is a testament to your sincerity, and my best of my prayers and wishes and my commitments and my dedications are with you on this journey. Thank you for your time and patience today. It's been a wonderful session for me. All right. Be in touch in some way or the other. Okay, last tip for pre. I'll tell you something for pre. Whenever you're looking at a question, okay, the first time you look at a question and the answer that you feel is correct, if you don't know the answer otherwise, mark it out. मतलब जो पहली दिल से आवाज़ आती है ना किसी भी आंसर क्वेश्चन को देख के, अगर आपको नहीं पता सर्टेनिटी से उसका आंसर क्या है, और अगर आपके दिल से आवाज़ आ रही है कि सही होगा पहली बार में, तो it is mostly the case it is correct. Trust your intuition and don't make prelims a safe game in which you are trying to calculate too much of, negatives and positive. Try to make more attempts in the examination. Okay, and listen to the intuition. Prelims is not going to be ever for anyone, even if a person is a topper. Maybe even the best of the people who are attempting prelims can't mark too many questions right directly. They have to do an intelligent deduction guesswork kind of a thing, to use all permutations and combinations, take a tip from an option, look at very difficult, very minute evidences which are given in the question as to what the answer can be. So you look at a question once and you may not get the question completely, but come back to that question and look at it again, and you may be able to find cracks in the question in which you can put a foot inside and crack the question. That is the beauty of the prelims examination. It's a very, what you can call, a kind of a case solving kind of a paper, in which once you don't understand the question, second time you don't understand the question, you come back to the question again, and maybe you find a way to deal with the question one way or the other. Okay, so keep an open mind to uh, uh, not having answers to the questions. It is very clearly possible that you may not know a lot of questions directly once you look at them, but don't take a sentence on those questions at that very point. Just leave it, return back after a point of time when you've marked the ones you know, and try to find joints in the question which you can use to find the least incorrect answer, and take some risk and trust your intuition. That's, I think, a good way to maybe go about some of the questions in the prelims. Okay, all right. Sarfaraz is here. Pranali is here. Okay. All right. Thank you so much, all of you. I will see you around. Be in touch, and all the best. Thank you. Now, one of the things that I can, at this point of time, introduce is an important current affair of Prevention of Money Laundering Act, the PMLA. It has been in news for a lot of reasons. Prevention of Money Laundering Act, and the provisions of the amendments which have been made to the Prevention of Money Laundering Act have been brought about under certain considerations. ठीक है, तो अब बात यह है कि प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट क्या है. अब it's a good point and you point out, I missed it out. दो डेप्यूटी स्पीकर के ना अपॉइंट या इलेक्ट होने का एक जो बहुत बड़ा कारण, थैंक यू फॉर रिमाइंडिंग मी दैट पॉइंट, डेप्यूटी स्पीकर के ना इलेक्ट होने का एक जो बहुत बड़ा कारण है वो ये है कि एज अ कन्वेंशन ऑफ द पार्लियामेंट, मोरारजी देसाई के समय से 1969 से 1979 ऑनवर्ड्स, onwards, the deputy speaker of the parliament was always supposed to be from the opposition party. Kind of a convention of the parliament. ऐसा कोई कॉन्स्टिट्यूशनल नियम या कुछ ऐसा नॉर्म नहीं है, पर एक तरह से एक प्रथा बन गई थी कि स्पीकर की पोजीशन रूलिंग पार्टी को जाती थी और डेप्यूटी स्पीकर की पोजीशन ऑपोजिशन पार्टी को जाती थी. कई लोग बोल रहे हैं कि जो आज के समय रूलिंग पार्टी और ऑपोजिशन पार्टी के बीच में जो पूरी तरह से तालमेल टूट चुका है, उसका एक नतीजा है कि अभी तक कोई डेप्यूटी स्पीकर किसी भी तरह से चुनाव करके बाहर नहीं निकाला जा रहा है. तो ये एक आपने अच्छा पॉइंट बनाया. थैंक यू फॉर रिमाइंडिंग मी सो दैट आई कुड एलैबोरेट अपॉन इट. ठीक है, ओके. प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट, पीएमएलए. ठीक है. अब इसमें ना जो हमारे पास मतलब इसको पढ़ने के लिए जो रीज़न है वो है कि अभी फ़िलहाल में ही सुप्रीम कोर्ट ने एक अच्छे खासे जजमेंट में कुछ चीज़ें बातें करी हैं प्रिवेंशन ऑफ मनी लॉन्ड्रिंग एक्ट को लेके. ठीक है, तो मैं आपको एक एडिटोरियल के माध्यम से इसको थोड़ा सा समझाना चाहूँगा. ये अच्छा खासा इंपॉर्टेंट डेवलपमेंट है. ठीक है. नाउ हियर इज़ अ पॉइंट दैट यू वांट टू मे बी रिमेंबर. Take a look at this. Outcomes in matters of constitutional law disputes depend on the values that the constitutional court choose to emphasize over those it chooses to discount. सुप्रीम कोर्ट का एक डिसीजन आए, डिसीजन का आप नाम लिख लीजिए प्लीज. आई वुड रिक्वेस्ट यू टू take a copy and a pen and just note a set of things about the PMLA. अगर आप, if you take a half page note about the PMLA, it can serve you good at the last moment revision of the questions that can come from the PMLA. ठीक है, just if you can take a set of notes upon this. The case that we are referring to is a case decided by the Supreme Court of India, and the name of the case is Vijay Madan Lal Chaudhary versus Union of India. Okay, Vijay Madan Lal Chaudhary versus Union of India, or you can also give it the name of the PMLA case. I'll repeat it again. The case name is the Vijay Madan Lal Chaudhary versus Union of India, also known as the PMLA case. ठीक है. All right. Now, the PMLA is an act which was enacted by the Parliament in the year 2002, and it has been amended from time to time. The act has been amended, I think, as recently as 2019 itself. Okay. Now, the point about PMLA is this: the Prevention of Money Laundering Act is specifically enacted in 2002, but it came into force in 2005, right? And the real reason, the intention behind enacting the Prevention of Money Laundering Act was to give a kind of a special focus on crimes which involve extraction of money, and to deal with that extraction of money in an expedited manner. For example, I'll explain to you. Let's say, this is a very simple conceptual thing that you can take a background understanding of and then grasp it very clearly. Let's say, for example, if I sell drugs and I get some cash out of it, okay, then what I am doing is getting money out of selling illegal substance, which is a offense which is punishable under the Indian Penal Code. Or let's say I steal someone's cash from ATM and keep it in my pocket. And the allegation, the charge that would be made against me would be the charge of theft. This is a charge under which I can be prosecuted. Theft. Clear? Now, let's say, for example, after I have been charged of theft, an FIR has been filed against me before the police station, and then the criminal law will be set in motion, and I will have to be presented before a magistrate within 24 hours if I am arrested, and the things will go on as much as possible. Now, while all this kind of a thing is happening to me in terms of my criminal prosecution, I am protected by the rights mentioned under Part 3 of the Constitution. Part 3 के अंदर जो rights हैं, for example, specifically rights under Article 20, under Article 21, and under Article 22. These are the three freedoms which are given under Article 20, 21, and 22. I have the protection of these rights, which basically means that we have discussed. Article 20 clause 3 बोलता है कि self incrimination नहीं कर सकता है व्यक्ति. Article 21 बोलता है कि life and personal liberty cannot be taken away except by the procedure established by law, and Article 22 states that every person has a right to be produced before magistrate within 24 hours of his arrest. So, if a criminal law is being applied against me, at the same time, to not let me be subjected to any brutality by the police or other administrative forces, it is necessary for me to also have the safeguard of the constitutional provisions. Take. So, the point that we may want to at this point of time highlight in terms of getting a sense is that the thing that I have committed is something that I will be punished for, but I can't be punished prematurely, or I can't be punished twice, or I can't be punished without the procedure established by law. Clear? So the agency which is prosecuting me, the police, is supposed to take its best steps to get evidence against me, but also it has to make sure that it does not violate any of my rights. Now, in, let's say for example, cases of money laundering, 2002 Act, I take some amount of money from somewhere, I steal money from an ATM, but now what I do is, rather than keeping the hard cash with myself, what I do is I layer the money, right? What does it mean by layering the money? What it means is that I send the money to a tax haven outside India, and in tax haven, the money gets invested into some company, and then that company starts buying stocks in some company which is registered in India, a Bombay Stock Exchange, and that company which is buying stocks in Bombay Stock Exchange, is giving returns to me in some or the other manner. So, agar मान लीजिए I create cash and I start layering it, buying property, making that property a registered office of a company, leasing that registered office and trailing the money 1, 2, 3 layers, then it is a little difficult for the police to catch hold of that money, and for that reception of the money back, which has been made more sophisticated by economic and financial planning, a separate act has to be introduced in addition to the Indian Penal Code, etc., etc., which deals with what you can call offences regarding money, which is known as the, what you can call, the Prevention of Money Laundering Act. Okay. Now, this is a special act which has been made in addition to the crimes of theft and stealing and burglary which have been alleged against the people. तो अगर कोई चोरी हुई है सिंपल, तो पुलिस उसको निपटा देगी, लेकिन अगर चोरी के बाद उस पैसे को लेयर कर दिया गया है, जिसकी पुलिस के पास, that police doesn't have that kind of resources to deal with that sophistication, you have to create a special act and a special agency within that act who has the expertise and resources and a focus to deal with situations only like this. And for this, the Prevention of Money Laundering Act was enacted. And the special agency which is supposed to be acting in the cases of money laundering under the PMLA is the Enforcement Directorate, ED. Okay. Now, since the enactment of PMLA, the PMLA has been amended multiple times, and the recent amendments to the PMLA have created certain provisions which have become subject to certain constitutional controversies. We'll take a look at those provisions, but let me give you a sense of it. The provisions in PMLA say that Enforcement Directorate is not bound by the constitutional safeguards which are applicable over an action of a police. Okay. Since the start, PMLA has been projected as a kind of a special law, a special expedited manner of getting things done, of dealing with sophisticated economic offenders. Okay. And therefore, it was not, the recent amendments to the PMLA suggest that the limitations or the, what you can call, the responsibilities which are given to the police to not violate certain fundamental features of the Constitution. For example, let's say Article 20 Clause 3, that police, anything that you say to the police cannot be taken as an evidence against yourself. This kind of a fundamental right is not supposed to bind the prosecution or investigation done by the Investment Directorate. मतलब ये मतलब एक्ट कहता है कि Enforcement Directorate के सामने अगर आपने कुछ कबूल कर दिया तो उसको आपके अगेंस्ट एविडेंस की तरह इस्तेमाल कर लिया जाएगा. ठीक है. तो ये सारी चीजें तो थी पीएमएलए में. एक तरह से एनफोर्समेंट डायरेक्टोरेट को एक तरह से एक अलग स्पेशल कैटेगरी ऑफ ऑर्गेनाइजेशन बता रही थी जो पुलिस जैसी नहीं है, और उस पर जो पुलिस के ऊपर सीमाएं लगती हैं संविधान के अंदर वो एनफोर्समेंट डायरेक्टोरेट के ऊपर नहीं लगेंगी. ऐसे अमेंडमेंट्स करके इस लॉ को थोड़ा सा पावरफुल बनाने की कोशिश की गई थी. इन अमेंडमेंट्स को सुप्रीम कोर्ट के सामने चैलेंज कर दिया गया ये कहते हुए कि दिस लॉ इज इन वायलेशन ऑफ आर्टिकल 13 ऑफ द कॉन्स्टिट्यूशन. मतलब आर्टिकल 13 के अंदर सुप्रीम कोर्ट कैन रिव्यू द लॉ बिकॉज इट इज इन वायलेशन ऑफ फंडामेंटल राइट्स 20, 21, 22 एटसेट्रा ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया. तो सुप्रीम कोर्ट के जजमेंट ने कहा है, जो विच इज द करंट अफेयर विच इज डेवलपिंग ओवर हियर, दैट द law which is made by the parliament in this particular matter is not violative of any fundamental right. And the Supreme Court has upheld the fact that the Enforcement Directorate within the PMLA is a special body which is not limited the same way in which the police is limited by the constitutional provisions. You see the point? This is one point that has been given as a judgment by the Supreme Court, a very important judgment which is forming a part of the current affairs recently. Second thing which was also a contention before the Supreme Court was that the amendments made to the PMLA were done by the route of the money bill under Article 109 and Article 110 of the Constitution of India. The money bill was used as a method to bypass the Rajya Sabha and get it passed only by the Lok Sabha. This also became a subject of challenge to the power of the Speaker of the Lok Sabha to determine a bill as a money bill when it is not falling under the conditions of Article 109 which defines the definition of money bill. तो ये दो चीज़ें थी जिसके बेसिस पे चैलेंज हुआ था सुप्रीम कोर्ट में PMLA, लेकिन सुप्रीम कोर्ट ने दोनों चैलेंजेस को दरकिनार करके जो कॉन्स्टिट्यूशनल वैलिडिटी है उसकी स्थगित मतलब उसकी स्थापित करती है. इट इज़ नॉट सेइंग दैट एनी ऑफ दीज इश्यूज आर कॉन्स्टिट्यूशनली गोइंग टू बी अ प्रॉब्लम फॉर द वैलिडिटी ऑफ अ लॉ. ठीक है, दिस इज वाई द PMLA हैज़ बिन इन न्यूज़. मे बी आई एम श्योर यू मस्ट हैव टेकन अ लुक एट सम ऑफ दीज एस्पेक्ट्स ऑफ द PMLA. ठीक है, तो मैं आपको ना थोड़ी बहुत चीज़ें अब यहाँ पर धीरे धीरे लिखवाने की कोशिश करूँगा जिससे कि आप इसको थोड़ा समझ सकें. ये वाला जो आर्टिकल है इसमें काफ़ी संक्षेप में बिल्कुल उतना ही दे रखा है जितना आपको किसी MCQ को सॉल्व करने के लिए यूज़ करना पड़ेगा. जैसे फॉर एग्जाम्पल मैं यहाँ से धीरे धीरे पढ़ना शुरू करता हूँ. द मेजर डेविएशंस इन द PMLA स्कीम ऑल ऑफ विच ऑपरेट टू द डेट्रीमेंट ऑफ द अक्यूज एटसेट्रा, वो ये है कि अब जैसे फॉर एग्जाम्पल जैसे FIR होती है उसी तरह से PMLA के अंदर जो इन्वेस्टिगेशन रिपोर्ट फाइल करती है ED उसको कहते हैं ECIR. ठीक है, तो इसको याद कर लीजिए थोड़ा सा. एंड आप एक इसमें लिखिए और आप लिखिए मेजर प्रोविजंस ऑफ द PMLA. मेजर प्रोविजंस ऑफ द PMLA. इसको अभी याद कर लेंगे तो तुरंत याद हो जाएगा. इससे एक आधा क्वेश्चन अगर आया तो बन जाएगा आपका. इसको बात के लिए मत छोड़िए. मेजर प्रोविजंस ऑफ द PMLA. ठीक है, इसके आगे लिखिए अंडर कंसिडरेशन of constitutional validity. Major provisions of the PMLA under considerations of constitutional validity. ठीक है, एक टाइटल डाल दीजिए और इसके नीचे लिखिए नंबर 1, नॉन सप्लाई ऑफ द ECIR enforcement case information report to the accused / arrested person. मैं ये ना उसी कंटिन्यूएशन में बोल रहा हूँ इस चीज़ को कि जहाँ पर इन्फोर्समेंट डायरेक्टोरेट को पुलिस से अलग बताया गया है और पुलिस के ऊपर जो लिमिटेशंस हैं संविधान के प्रिंसिपल्स की, वो ED को थोड़ा सा उनसे राहत दिलाती, जैसे कि ED अपना काम जल्दी कर ले और प्रॉपरली इंसाफ दिलाते. ठीक है, लेकिन इसी वजह से ये कॉन्स्टिट्यूशनल मतलब वैलिडिटी के लेवल पे चैलेंज हो चुका था, क्योंकि बोल रहे थे कि आर्टिकल 13 में जुडिशियल रिव्यू के अंदर सुप्रीम कोर्ट शुड स्ट्राइक दिस नाउ. तो पहला पॉइंट लिख लीजिए, नॉन सप्लाई ऑफ एनफोर्समेंट केस इंफॉर्मेशन रिपोर्ट ECIR टू द अक्यूज्ड / अरेस्टेड पर्सन. Okay, non-supply of the enforcement case information report to the accused / arrested person. ठीक है, ECIR is exactly the same thing as an FIR. अब ECIR के ऊपर क्वेश्चन आ सकता है कि फॉर एग्जाम्पल विच ऑफ द फॉलोइंग एजेंसीज is referred or is connected to the term ECIR which was recently in news. पहला आ सकता है CBI, दूसरा आ सकता है RBI, तीसरा आ सकता है विजिलेंस ब्यूरो, चौथा आ सकता है एनफोर्समेंट डायरेक्टोरेट. करेक्ट आंसर इज ED. Okay, so just in your mind take note of how MCQs can be created out of this kind of a complicated activity. Okay, right, next point लिखिए, power to make any person पावर टू मेक एनी पर्सन स्टेट द ट्रूथ ऑन ओथ इवन दो इट मे अमाउंट टू सेल्फ इंक्रिमिनेशन। ठीक है, अब मैंने आपको बताया था कि आर्टिकल 20 क्लॉज 3 के अंदर सेल्फ इंक्रिमिनेशन पे अगर कोई क्वेश्चन आया तो वो यही आएगा कि जो पीएमएलए है वो बोलता है कि अगर मान लीजिए पुलिस किसी व्यक्ति से साइन करा लेती है किसी पेपर पे कि मैंने चोरी करी और मैंने चोरी करके प्रॉपर्टी खरीदी है, तो उसको उसके अगेंस्ट एविडेंस की तरह यूज किया जा सकता है। इट विल नॉट बी सब्जेक्टेड टू आर्टिकल 20 क्लॉज 3 ऑफ द कॉन्स्टिट्यूशन ऑफ इंडिया। द पावर टू मेक एनी पर्सन state the truth on oath even though it may amount to self incrimination। ठीक है, उसके बाद तीसरा लिखिए, राइट डाउन द थर्ड वन, राइट डाउन द थर्ड वन। Once a person is accused of committing the offense of money laundering, the burden of proving that proceeds of the crime are untainted property shall be on the accused। ठीक है, जनरली क्या होता है क्रिमिनल लॉ में कि अगर आप किसी पे एक्यूजेशन लगाते हैं तो जो एक्यूजेशन प्रूव करने का जो भार होता है ना, एक्यूजेशन प्रूव करने की जो रिस्पॉन्सिबिलिटी होती है, जो जिम्मेदारी होती है, वो होती है प्रोसिक्यूटर पे, मतलब वो होती है पुलिस के ऊपर। लेकिन इसमें जो बर्डन ऑफ प्रूफ है कि मतलब आप, जनरल प्रिंसिपल ऑफ क्रिमिनल लॉ इज दैट द पर्सन हु इज गिल्टी is considered innocent unless he is proved guilty। The person who is charged of a particular crime is considered innocent unless he is proved guilty। बट इसमें इसको उल्टा कर दिया गया, इसमें उसी के ऊपर रिस्पॉन्सिबिलिटी दे दी गई अपने आप को इनोसेंट प्रूव करने की। ये भी एक क्वेश्चन था जहां पर कि सुप्रीम कोर्ट के सामने इस चीज को लाया गया था। ठीक है, तीसरा पॉइंट। ठीक है, तो ये जो 3 पॉइंट है ये आप एक तरह से देख सकते हैं जो थोड़ा सा कंट्रोवर्सी के घेरे में आ गए थे और इन पे किसी ना किसी से जोड़ तोड़ कर कोई क्वेश्चन ये लोग बना सकते थे। ठीक है, और इसके बाद जो एक बहुत बड़ा पॉइंट था वो ये था कि जो इसके अंदर अमेंडमेंट्स पास किए गए थे वो अमेंडमेंट्स मनी बिल की तरह निकाल के दिए थे। तो मैं थोड़ा सा बस इसमें यहाँ पर आपको एक रिविजन के तौर पे जो